So I want to welcome our member benefit provider partners, Thomson, Reuters, Westlaw today, and our local rep, the guy, the man, the myth, the legend, Nick Dolan. He can help you do what you need to do, and they have some special pricing for our members. So they will be able to tell you all about that later, and then they're going to tell you about some of the new products that they are really interested in having you use because they want you to know that the courts are using these products. So that's part of the reason we're doing this today, to keep everybody up to date and current. So I'm going to turn it over to Nick. Nick, it's all yours.
Thanks, Ann. So my name is Nick Dolan. I've been with Thomson Reuters for about 8 years now. I have, some background working with corporate counsel, in-house counsel in San Francisco a few years back, and then I've been working with law firms since. So I am local to Oakland, and if there's any questions about any of this stuff, feel free to reach out to me. I know Ann's kind of sent out my information. But we'll have two presenters here today. The first is going to be Devin Bullock. He has a background working in some federal courts. He is a product trainer. He's going to really focus on showing everybody here the new Westlaw product that is on, the entire Department of Justice is utilizing it now. They signed up at the beginning of the year. And then since then, some California Supreme Courts, California Court of Appeals have also logged on, and more are gaining access. The second part of this is going to be with Bryan Schwartz. Bryan Schwartz is a attorney editor we have, so he actually has a very unique insight into how a lot of these products are made. He's going to be showing a product which I think is very relevant nowadays. It's essentially a product to help you navigate some of these new issues you might be seeing with the environment that we're going through, and really help you retain and grow your business, since might be some different practice areas or some new issues that are coming up. So I will stop talking here, and I will hand it over to Devin to start going into Westlaw Edge here.
Perfect. Going to go ahead and share my screen now. Everyone should see my PowerPoint deck up here, my lovely face and contact information. But good afternoon, everyone. Today, we're going to be really focusing on artificial intelligence in the law. And depending on your thoughts on artificial intelligence, that might scare you a little bit, that term. Well, where is it going to take us? How is it going to develop? And I can tell you that it has already expanded into the field of legal research, and it's already helping attorneys, judges, and ultimately the clients that are being served here to better find case law that is right on point with the issues and find better arguments, and to just make sure that you don't miss anything. So just to kind of give you an idea of the vast amount of case law, changes to statutes and everything that occurs every year, the law is constantly changing. If we look at this, these numbers were from 2018, but on average, this is about the normal amount of changes to federal and state statute sections, federal and state admin codes, and new and unreported opinions loaded onto on Westlaw. So at the end of the day, these numbers are vast, and of course, they each relate to different areas of the law, but all of them have one number in common that is ultimately the most important to you and, of course, to your client. It's that number one. It's the one that keeps you up at night. Did I find that case? Did I go far enough in my research? Did I dig in the places that I needed to go to find the best law related to my client's matter and issue at hand? And AI is helping make sure that you don't miss that one. And specifically with us, we built out the new platform Edge, and the one that we'll be mostly focusing on today, Quick Check, which will go through and do document analysis for you, read through your facts, your arguments, and the associated case citations with it to make sure that you don't miss any related cases or factually relevant or analogous cases to the arguments that you have. To give you a bit of a background on Edge, about 8 years ago, if you'll remember, IBM and Watson partnered together to come up with the Watson AI, which at the time, of course, was one of the most revolutionary changes in artificial intelligence and machine learning. And right about that time came out, we decided as a company, well, how can we apply this to legal research? Is there a way that this can benefit attorneys, judges, and of course the clients in making sure that you have a full and total view of the law to find things that you normally wouldn't find just because it's too time consuming or tedious to find, or the client wouldn't pay for it if you did. So we can think about legal research. We want to analogize it. We can think of it like fishing. If you've ever been fishing before, you'll know if you go out on the lakes often enough, you kind of get a certain idea of where you want to go fish, where you've been most successful in the past, and you tend to stick to that place. You don't go to those other places in the lake where there might be a big fish down there, but it's too time consuming and you're not likely to find it. You want to focus on where you'll get the biggest payoff in your research and with your time. So we'll think about it to a legal lens now with a question like this: whether an unjust enrichment claim for theft of IP is preempted by the Copyright Act. To find the answers in case law and everything relevant to this legal issue, you might hone in on terms of art such as unjust enrichment, direct citations to precedental cases, or on Westlaw, things like the key number system, our indexing system for all the law that's come out for the last 150 years or so. The problem is if you only focus on just those things and you don't go too far past the surface level or too deep into it, you miss a lot of things specifically related to this question. To get a full view of the answer to this issue, you would need to look into similar concepts like equitable remedies, preemption doctrine, or down into the vast extended citation network of cases that have examined and interpreted this law, or more related key numbers like copyright, states, and conversion. Really, honestly, most of us don't have time to go into each one of these spaces. And even if you did, there are so many document relationships to it that the terms might not be correct that you use, or you just might not find the best thing. Even if you're an experienced legal researcher, it's just sometimes you only can go so far. So what AI is helping doing with that machine research and artificial intelligence is we have taught the AI behind QuickCheck and Edge the law and legal terminology. I said we partnered with Watson and them 8 years ago, and we took their AI up to our own AI lab in Toronto, and we spent that time teaching it the law, legal terminology, syntax, and context of those words and how they relate to the citations within the argument, as well as teaching it to read the facts in the argument itself as they relate to those citations, so that it could actually go out and find the actual most relevant law, the most factually analogous cases. I'll give you an example of one that we ran through whenever we were doing this partnership. We partnered with a lot of firms to go through and analyze some of this to teach QuickCheck better, the better research skills base. We sent it to law school. So one of the ones we went through and found was a False Claims Act brief that, with the False Claims Act, it's a federal law that imposes liability for defrauding government programs. In this particular case, there was the plaintiff's brief. They claimed that a hospital had submitted bills to Medicare for services rendered, but the hospital was not an eligible Medicare provider when the services were provided because they had let their business license lapse. Therefore, the hospital had defrauded Medicare and was liable under the FCA. In summary of their brief with the defendants, they claimed that the hospital had made no false claims in the medical services provided. The only error that they had was allowing their business license to collapse. And while the license was necessary for medical provider eligibility, eligibility is not material to the government's decision to pay the bills submitted to them, and that the government simply considers whether services were provided and whether the bill is accurate. Therefore, the hospital is not liable under the FCA. Now, the citations that they used to back this up, they were fairly on point, but of course they weren't completely factually analogous. They only, slightly backed up the proposition. It wasn't the most persuasive argument, most persuasive authority to back up that argument. So we ran it through QuickCheck, and the first one that came up was this A1 Procurement LLC versus ThermCore Inc. It is a recently factually analogous case to the facts that were in that brief that was analyzed here. Just briefly looking, you can see the QuickCheck relates it to the specific arguments under the headers and tells you which cases that this recommendation relates to. If you were to look back at that brief, these were both the authorities that were cited for that specific argument there. So looking at A1 and the authorities and arguments in defendant's brief, on the defendant's side, hospital Medicare provider, they said they qualified as Medicare provider with a proper business license. Over on A1, it was a military government contractor related case, still under FCA law, where they said they qualified, or the opinion said they qualified as disadvantaged government contractor by meeting the financial cap. The analogy being that they both met the condition for the government program eligibility. In defendant's brief, they said the business license lapsed, whereas in A1, the contractor exceeded the financial cap. Analogy, they both fell out of compliance with the condition. Defendant side again, medical services were rendered properly and the bill to Medicare program was accurate. On the contractor side, being that the military services were rendered properly and the invoice was accurate. Analogy being no false representations in requests for payment or services rendered. And therefore, in the defendant's argument saying that non-compliance with business license requirement was not material to Medicare's decision to pay that bill, so there should be no FCA liability. And the court finding in A1 that non-compliance with the financial cap was not material to the government's decision to pay invoice, so there is no FCA liability. The ultimate conclusion being that non-compliance with an eligibility requirement does not make payment requests subject to FCA liability. We had our partnered firms, a bunch of AmLaw 100 big law firms, run through and kind of try and find this case as they would normally do in their research. And we found that this case was incredibly difficult to find through normal research methods, even when running very targeted searches. We see some of the best ones that they were able to come up with, both Boolean and natural language logic. If you look at the top two Boolean ones we have up here, A1 procurement wasn't even found with this. With the plain language, even one of them wasn't found. And if we go down through these other ones that were used, this one, Material Omission False Claims Act, the A1 was 313 of 664. Non-compliance after the fact, False Claims Act, 64 of 89. And finally, False Claims Act, failure to disclose, lapse of license, 30 of 65. I don't know about you, but back when I was working in the court and then thereafter in the firm, I normally with my searches, I did not go that far down. Of course, with relevancy in the search features and my own search knowledge, I generally stuck with maybe the top 20 or so, and then the associated citations in the head notes or any citing references to go along with that. Most likely you would have missed this case, even though it is directly factually analogous and a better argument to back up your proposition of law. So with Quick Check, it was able to find this, and it's really going to help as far as the AI goes to make sure that you have a full and encompassing view of the best authority, most factually analogous cases. This is what AI is doing for the legal research field. Specifically with ours, it's many use cases for it. Repurposing old briefs or memos, you go to your brief bank and you pull out ones that you have been successful with before as an outline. And if you're repurposing some of the citations and arguments, it will quickly let you know if anything subsequent has come out that's better authority or new counter arguments or interpretations of that law that have come out. Or analyzing the opponents, where quickly finding the weaknesses or authority that they omitted to you as well. Early drafts, anything that go into a colleague, anything it doesn't have to be a pleading or or any type of filing that you're going to do. It could be anything with a legal argument and case law citations backing it up. So we'll actually hop over just live briefly here so that I can show you on Edge just where it looks like and what it does here. You would just get to it from this quick check button there, and you can use it as much as you wanted to. Depending on what you're actually analyzing, it gives you a few options for the workflow, because you look at your own documents separate than what you do with opposing counsels. There's a separate process as far as how you analyze that. So you would just choose the one, and of course, like Nick mentioned, the courts are using this as well. And soon you'll also be able to see what the judges actually see when they run, or their clerks actually run sometimes. Having been a clerk myself, I'll tell you, I was most often the one doing this type of work. But you would just go in and you would select the document, drag and drop it if you wanted, or even just copy paste an issue statement with the argument that's related. This is all encrypted end to end as well. No one ever sees it other than you and the AI. And once the AI is done reading it, shreds it from the system. On our end specifically, I know no TR employee, contractor, or otherwise ever sees your work product, and it's never released to anyone. And it's pretty quick as well. Of course, the nature of AI and machine learning, it can do things a lot faster than people can, and it does that with Quick Check. I've ran through the one I have just as an example today is an 8-page memorandum in support of a motion to dismiss. I think it's also false claims related, if I remember right. But I've also ran through a 52-page brief with over 100 and something citations in it, and it took it less than 5 minutes. So it can get to all of this a lot faster than any normal researcher can, of course. So I ran it in both ways just to show what it looks like in both. So this is the checking your own work. Like, this is my document. So of course, first off, I wouldn't really care too much about maybe the warnings for cited authority or my own table of authorities, because I know what I've cited. So first, it just gives you the recommendations based on the headers and the arguments within, organizing the case law to just put it where it applies. So it's not like a long list of authorities you need to dig through. It tells you where it's coming from, which citations it relates to in your argument, of course, a synopsis of it just for simplicity's sake, and letting you know, of course, that it's coming from a higher court or more frequently cited. This way you get the most persuasive arguments out there. Of course, warnings for cited authority, letting you know if this is repurposing a brief or pleading, whether something might have changed in the key cite treatment, the citator system, to make sure that nothing has changed to those citations since the last time you checked it. And then lastly, the quotation analysis, which I really wish I had had this one when I was a clerk, because reading through quotes and associating them with the opinion itself was always one of the most tedious things I did. I would get cross-eyed and having to look from one screen to the other, from the actual document to the opinion, whereas here it will lay it side by side, each quote made in that document, and tell you where substantial differences have been made, or any changes to that law has been made. Of course, language in the law matters. Even changing a single word can change the entire context of the law as stated there. Whereas here we just say, for example, can prevail, as was stated in the uploaded document, from where the actual cited opinion said it must prevail. This is allowing you also to make sure that the opposing counsel is not pulling the wool over your eyes, or pulling what I like to call creative lawyering to actually change the meaning of the law, to take it out of context. And then briefly, last one on the opposing counsel's view, just to show how the workflow changes up. Of course, whenever you get opposing counsel's documents, you read through it, then you read their arguments just to make sure that everything's good with that. And then you look at the citation treatment of the cases that statutes, and everything else they've cited therein. Then to the quotation analysis, their table of authorities, finally, before getting to the admitted authority, so that you can better start on your research and actually find every analogous case or better case out there, any counter arguments available to counter their proposition of law. One thing that I didn't mention inside here, you might have seen this as well. We'll move on from Quick Check now to the next one, which is another new feature that AI has allowed us to do, which is the overruling risk flag. So we'll hop back over to this to the PowerPoint I have and quickly move down the line to it. So to give you a background on this, every system of citation today outside of Westlaw Edge relies on a direct citing relationship in order to apply a flag, or the Lexis parlance, to shepherdize it, to properly see that there is negative treatment to that case. The issue with that is that anything that is not directly citing to that now overruled case in that proposition of law does not receive that proper shepardizing key cite flag treatment. We'll give you a real life example that came out of Florida in 2007. They had the R.J. Reynolds tobacco litigation, which absolutely overwhelmed their dockets. And those courts, it went from you were originally getting a hearing in front of the judge in a few weeks to a couple months, to you were not seeing that judge for at least 3 years. They were so overwhelmed, and it was collapsing their dockets. They needed to do something about this, but they had to overcome forum nonconvenes. Of course, the presumption against disturbing the plaintiff's choice of forum. They decided, though, for the purposes of the R.J. Reynolds tobacco litigation, they were going to give that presumption less deference when plaintiffs were from out of state. Exigent circumstances aside and everything, this is a huge proposition of law to just completely change like this. It worked for them as far as the R.J. Reynolds tobacco litigation went. It alleviated their docket load, and they were able to continue on and push things through. The problem is that, with the law, of course, once an opinion is out there and published and up for continued citation and interpretation, it can be made the law of the land like this. And that's what happened in the subsequent year when an appellate court case, Kersner, decided to make this presumption, giving that less deference, the law of the land there in Florida. And they did for a few years. If we look at this, we have Kersner, it came out in 2008, and for 5 years until Raby Cortez from the Supreme Court came and directly overruled it, that was the law of the land in Florida. And as you can imagine, with such a huge proposition, a lot of huge change to something in such as venue like that, you can imagine thousands of cases were citing to this proposition. And most of them, after a while, were no longer citing directly to Kersner. Like this ABBA Capital Markets case, you can see it directly cites to Rolls-Royce, which directly then cited to Kersner. So once Kersner was overruled, all of these cases relying upon that proposition of law were no longer good for that proposition of law. And everything directly citing to Kersner got that red flag treatment, that shepardizing. But you have implicit overrulings out there. And ABBA is an example of an implicit overruling. It is not directly citing to Kersner, therefore not directly relying upon it. It is implicitly relying upon it because it is using that same proposition of law, although not directly cited to the directly overruled case, Kersner. If we can look at a representation of a citation network, a citation tree, as I like to call it, you can kind of see how this could get complicated really quickly. So pretend that we've got Kersner down here and Cortez directly overruling it. everyone with a line directly to Kersner here is getting that red flag, that shepherdizing treatment to tell you that that proposition of law is no longer good. But just like I said, that was a huge change to venue and everything, that there are so many cases out there that are implicitly citing to this proposition of law from Kersner, but not directly citing to it and therefore not getting that flag. So all of these out here don't have that treatment, and you would find those in your research. And when I was clerking, I was originally, of course, not so experienced in key citing or shepherdizing whenever I first got into the court. So my judge sat me down one day to give me a little lesson on it and to what you would have to do to make sure these cases out here in the penumbra of this citation tree were still good law if you found them. He called it the rule of three. You would identify that citation in the pleading, go into that opinion, and then go back at least 3 levels of citations from the pin site there to make sure that no case down the line had been directly impacted by an overruling for that specific proposition. It was time consuming and tedious at best. And, at the end of the day, you wondered, did I go far enough? If it was something that had been so set in stone for so long that no longer was that case being directly referenced in an opinion, did I move back far enough to find it? So how we applied AI to this is we gave our attorney editors, the ones who go through and read and put the head notes and key numbers to this AI tool to flag those cases for their review, not just handled by a computer. Everything is still handled by an attorney editor, but you would have to hire so many of them to find all of these cases out here that it's just not effective or efficient in any type of business sense. So the AI tool has actually greatly helped with finding these and better flagging and saving a lot of time for people. We go back over to the live here. I'll go to a case underneath this, Whitmore versus Arkansas. Now, just like any other flag on Westlaw that you would see, if it's got one of those implicit overrulings, you get this new key cite implicit overruling risk flag. And with this, you also tell you, just like any other, where it is coming from right at the top, and also tell you which point of the opinion has been impacted. Oftentimes, of course, opinions can be multifaceted, covering multiple sets of issues and many different layers of law within. So you can hit the next term, though, and see exactly, and I hit this little button there if I did that too fast, you can see exactly the point of the opinion that has been impacted by that overruling down the line, though not directly cited here in Whitmore. And you can tell it went from Franz v. Lockhart here. If we look, the same overruling risk exists on this. So somewhere well down the line of citation in this tree, you'll find that a case has been directly overruled by State v. Robbins here. So at the end of the day, what this really does is make sure that you don't cite bad law to the courts. It's called being proverbially slapped from the bench by the judge. I've seen it happen many times when I was clerking, and it was it's not fun to watch, even for someone not directly involved in the matter. You never want to do that, because it can quickly ruin your reputation in that court with your colleagues and peers in the area. So this is another tool that AI is helping attorneys with to flag these cases, so that on the face of it, you're better able to immediately identify if that has been implicitly overruled down the line. I know I'm running up quickly on my time here, but I will just briefly feature another one that has been added. There are several places that this has been the AI has been implemented across Edge. A new Google-esque type of searching where you can actually ask a broad legal question of it, and the AI will go out and try and find that answer, just like you would normally with Google if I ask where's the local coffee shop, best local coffee shop, or something like that. But briefly, again, before I turn it over to Bryan, we'll just briefly touch on litigation analytics and how this is helping attorneys with understanding the ruling tendencies of judges and courts and how certain case types tend to go. Different courts are more plaintiff friendly in cases versus defendant friendly. So if you have a choice of venue, sometimes you want to do a deeper dive and look, maybe call up a friend from the bar association or someone you went to law school with to see how does this judge tend to rule when a specific case comes forward. I'll just type in a judge here in the Northern District of Texas, Ed Kincaid, so you can see all of this. Looking at this, it briefly highlights the ruling tendencies of these judges, where their biography, timeline, and contact information, and also their tendencies to rule on specific motions when filed by a certain party in certain case types, as well as how long on average it takes for them to grant a ruling on this specific issue. From this, you could see all of the dockets that this judge has ever seen to get an idea of their experience. If I'm bringing a torts negligence, maybe products or products liability, motor vehicle, something of that nature, the judge is probably fairly up to speed on relevant tort law. But if I was going down further to forfeiture and penalty, I might have to brief the judge a bit more because it doesn't seem like he's had too many of these cases in the past or maybe recently. You can even see all by year how long ago the last one they had was. With outcomes, you can see how do these cases tend to end, and you can get very granular with the data because it's all hooked up to the key number system, where you can filter down either by clicking on the graphic or to the left to the different types and sub issues of the contract law, for instance, here to see on average when a insurance contracts case comes in front of Judge Kincaid, how often does it end in a certain way through here to get a better understanding of your likelihood of success, or to review other cases that have been successful to check for facts or the arguments made by those attorneys to see why they were successful. And again, like I said, time to outcome. Of course, the one thing the client always asked when I was in the firm was, how long can we expect to be here? How long is this going to drag on? But this gives you a data-driven insight to understand how long you are likely to be in a specific judge's court for a given matter with this. Motions get very granular with the filing role, type, and everything to see how long it takes for a judge to rule on a certain type of motion when filed by a certain party in a certain case type. Combining this data in multiple different ways, getting very granular, you can see all of that, along with how long you can expect for an answer to come from that judge, before you can expect for an answer to come from that judge, just so you can better formulate litigation strategy. And precedent analytics also tell you the precedential cases that this judge most often finds persuasive in their opinions, where you can filter down to all these different given areas of the law and subset issues through here to find the precedential cases that this judge is likely to rely upon in your issue, if it's one of these here that I've seen before and has given a ruling on. Expert challenges will tell you how they have treated their experts in the past, whether they tend to see whether the testimony is passed à bear, and we see whether that testimony has been admitted, excluded, or admitted in part, excluded in part. Also help you better vet your expert witnesses if they've been in front of that judge before to see how their testimony was treated in the past. And then finally on appeal, and I say finally because references will just tell you all the opinions, trial court orders, and everything this judge has rendered. The appeals will tell you the appellate history of this judge, whether to their court or from their decisions, just to see any past cases that might have had some similar procedural issues on appeal or anything that you were going to move up for appeal if they were similar to ones you might be trying to appeal. To better advise your client or see for yourself whether that would be worth taking on. What's the likelihood of success coming out of Judge Kincaid's court of an appeal of this type when this same matter has been seen before, if it has been seen, of course. But you could go down and check all of those to see if they were similar issues on appeal to yourself. And that's our overview of artificial intelligence as it relates to Westlaw Edge. I hope that you got a lot out of this and better explanation of where the industry is changing, what tools are available, and what you can likely expect to see in the future from this. So for my part, thank you so much for your time. I hope you have a fantastic rest of your day. Please feel free to reach out to me or Nick with any questions, and I will turn it over to Bryan.
Wow, that was something. I guess like the old Monty Python, I'm going to have to say it now for something completely different. My name is Bryan Schwartz, and as Nick said in the beginning, I'm a legal editor, and actually very recently out of practice, just came out of practice. So not only an editor, writing content, maintaining content, but I'm also a recent former user of the product. And I've got a lot to say about that. But first, I want to thank everybody for being here. And it's especially great to speak to members of the California bar. That was my first bar. And I enjoyed several wonderful years in law school in California and practice. So let me see if I can figure out how to share my screen with you guys today, because that's obviously got to be the first line of business. How is that working, Ann?
Bryan, it's Devin, not quite shared. Now you're sharing.
All right, so you got me up there?
Yes, sir. Have your desktop.
All right, do you have Practical Law Connect up?
No, go ahead and open up Chrome down below.
How about now? Do you have it now?
There we go. Yeah, just maximize the window up there by dragging it up. There you go. Perfect.
All right, great. So what we're looking at here is the landing page for Practical Law Connect. And let me just explain briefly what that is. My whole goal right now is just to give you an overview of what Practical Law Connect is and show you the basics of how to use it. And I think this will really be a tool that you'll like. It'll enhance your practice, as Nick said at the beginning. A lot of stuff going on right now, and it provides a very useful place to be able to create things on your own and to be able to find answers to questions very quickly. Now, Practical Law Connect actually marries with Westlaw, so that's a great thing about it. And it's kept up. It's a database that's kept up constantly by a team of over 300 editors like myself, all of whom have over 10 years of practice in the field. And I know I used to wonder who was keeping these things up when I was using the product and could see how good they were. But now I know that they really get people who are experts in the field and who've been out there for a while. I guess the essential difference between Westlaw and Practical Law Connect is really, as Devin was showing, Westlaw is about finding the law and doing your research, whereas Practical Law is practical. It's about applying the law, finding know-how, finding forms, and being able to use them very easily. So in the center of the screen, where I'm at right now, you should be able to see a bunch of different areas. These are our practice areas. They run from antitrust to trusts and estates. And, the breadth of them is just astonishing. You can click into any one of these and find pretty much anything you're interested in. You can also click up here on this toggle and go into Westlaw right here if you want to do that. So let me show you a few things about this landing page before I get off of it. One of the things that was mentioned before was how artificial intelligence is improving things. So if you typed in something like, let's say, I'm a patent litigator, so I'll type in patent settlement. And as soon as I start typing, the databases that contain information within Practical Law and the types of resources that contain information on patent settlements pops right up here. It's actually better than Google. Devin mentioned Google, but as we all know, Google's ranking system is kind of bought and paid for in a lot of respects, and ours comes up to exactly what you need to know here just by typing. So that's one form of search that you can do when you're looking for something. You can also click into your practice area, which I'll do in a moment. And I know when I took some of these courses as a lawyer, these screens go by so fast, and it's difficult to pay attention to and to take it all in. But as you're scrolling down the screen, you'll see a bunch of other different areas that we have resources in, and we won't be able to get into most of these today. We're going to stick with the practice areas, but you can see at the bottom you get your Reuters news. Even the news feed comes in for you at the bottom of the page. So that's what's on our landing page, as we call it. Now I'm just going to click into an area. Really, these are the great thing about these is the look and feel of them is really, it's all the same. So when you click into one, I clicked into intellectual property because that's my area and I like it. But you could really click into any of these and you'd see the exact same type of interface. And so what you do here is you can scroll down, and again, you'll see some resources. And here you get to see Reuters news that's particularized to your specific area. So you can see here, the first entry is a case about an article about Fitbit and the Federal Circuit nixing or giving Fitbit another shot at nixing a biometrics patent. So these are the kind of articles that will populate for you if you click into intellectual property. But I want to focus mainly, and I think if you're using this tool, you'd focus over here on the left, if you can see where my cursor is, on the tasks and projects. Now the tasks and projects aren't just populated by artificial intelligence. This is not done by bots. This is done by real life attorney editors, and they make the selections on how to set up the tasks and projects that in the best organization that they think will work for you. So you can see here under intellectual property, we have patent counseling, patent transactions, litigation, moving on down to trademark, copyright, trade secrets, et cetera, all the way down. There's an extensive resource database on privacy and data security, and internet and new media as well. So the way to access these tasks, so again, I'm gonna pick my area. You could pick any area. It really doesn't matter. As soon as you click on the drop down, you're gonna see a bunch of different tasks. Under patent litigation, you're seeing claims and defenses, early case assessment, motions, discovery, trial, etc. And what I'm going to try to do here now is I'm going to click into a task. So let's say today I need to do a settlement agreement or a covenant not to sue in a patent litigation that's about to settle. Or I'm an in-house counsel and I want to check that what my lawyer is telling me is a standard type settlement truly is a standard type settlement. So I'll go into this task and I'll come to another page with this very similar interface to the ones you've been seeing. And now at this page, I'm going to get the curated resources that our attorney editors put on the page for you. Practical law know-how, which my cursor is at right now, is our main body of work, and it's really divided up into 3 different categories of resources, 3 different categories of know-how. You get, within here, you can get there's the basic know-how with checklists, practice notes, and other curated pieces that our editors write. Down here in the middle, you'll see forms and standard documents, some of which our editors also write, and I'll show you one of those in a minute, because after all, our task today is to find a patent settlement agreement. And then we have down here at the bottom, secondary sources, which all lawyers are familiar with, and many of these resources, such as the Annotated Patent Digest by Matthews, are pretty key resources in the area of patent litigation that everybody uses. And they can be very handy if you need to go outside to a secondary source. So as I mentioned, there's essentially 3 key pieces to the practical law know-how resources. There's practice notes, which I'm pointing at. There's checklists, and down here, there's standard documents, and I'll explain each one of those as I go through them. So I'm going to just click on this practice note, which is patent litigation and patent settlement agreements, and I'll show you a little bit about that. It's going to come up for me. So a practice note, rather, is they come in a variety of flavors, but basically they're how-to guides. They can be overviews, sort of primers on an area, or they can be more detailed analyses, depending on their purpose. So in some instances, when I was practicing, I would use these kind of documents to get an associate up to speed, to get a colleague up to speed, or sometimes I would get myself up to speed because I'd either have become a little bit rusty in an area of law or was completely unfamiliar with an area of law. one of the great features that I really loved in practice about these practice notes was the table of contents on the left. These hyperlinked table of contents are so useful because you really don't have to page back and forth between a hard copy of a treatise or flip like you do in some instances between pages in an online resource. You can just click on one of these and it'll take you to the heading. So if you wanted to go to dismissal of the litigation, you could click right here. It would take you down to that portion of the practice note, and there's the heading there. So let me go back up to the top where I was, just so I can explain a little bit more about what you would see up here. And you're going to see this in every practice note. And that's another wonderful feature in the sense that when you're trying to get up to speed on technology as a lawyer, you only have so much time. And the fact that when you're in practice, you can really rely on the fact that these notes are all set up in the same way. They all have this abstract here, which explains in a couple sentences the purpose of the note. And then they have, almost all of them will have this annotation here in green saying that they're maintained. What that means is, pardon me for a second. What that means is that this particular practice note, and like I say, most practice notes, get the attention of the attorney editor's eyes at all times when there's a change in the law. And we and my colleagues, it's part of our job. It's what we spend our entire days doing, is writing and maintaining these resources. So if there's a change in the law, we'll go into the resource and republish it, and we'll send out, that'll create, if you set it up, an alert for people who are looking at this resource. But more importantly, it keeps the resources completely evergreen when you're looking at them. So I was just, stunned, I guess, when I took the job at Practical Law as to how much time people spend on these, how careful they are. And I was always skeptical because I know that when I was using treatises in practicing law, they weren't current, even though they tried to keep them current with pocket parts, etc. These resources are extremely current. As you scroll through one of these practice notes, you see also a lot of hyperlinks within them. So you see hyperlinks that'll get you to glossary terms in case you don't know what a particular term is. Patent Trial and Appeal Board, you want a definition of it, you can click on that. It hyperlinks to other places within the document itself so that you can, if you're reading about something and you say, well, I want to go to that section of the document, you just click on it. And also there's, hyperlinks here to actual law. So here's a hyperlink to the Federal Rule of Evidence 408. There's another one down here to an important case on reasonable royalties from 2017 called Prism Tech. And it's on and on. These kind of hyperlinks make your job so much easier. They really enhance your experience because what you get is a one-stop shop. You're able to get your law fast and efficiently by having these hyperlinks in the document. Let me see if there's anything else I wanted to show you about this. I think the one other thing I wanted to show you is this button right here, which stays up constantly. If you want to go to see other practical law resources that are in the same area, maybe you don't feel like you got to the right resource. Well, you can click on related content and you can see there are a bunch of other resources down here that the editors have decided are related, not a bot, but the editors. And they put them down here and they link them when they publish the documents. So let me see if I can go backwards for a minute and show you a couple other types of documents. So I mentioned checklists, and a checklist is really just sort of, it's triggered by the practice note. And what it does, it gives you a sort of bulleted list of items. In most cases, that's what it does. In this case, it's going to give you a bulleted list of items about drafting a patent settlement agreement. So you have your checklist. Your colleague or your associate can use this to check themselves. You can use it in advance of starting your drafting. You can use it as an agenda for a meeting if you have a large document. Patent settlement agreement is not one of those, but if you were drafting a large document that practical law covers, which is most types of documents in most areas, you could actually use this as an agenda for a meeting. And as you'll see, it has the same features I mentioned before. It's maintained. It has the related content button here, and it has the abstract that tells you what it is. So checklists can be good. Some of them are in charts, and some of them are just in bulleted lists like this. I find them very helpful. Let me take you back to a third type and the third principal type of resource. So I'm going to scroll down to forms and standard documents. And you can tell if you're in here, if you were playing around with a trial of the product or something and you wanted to be able to tell, well, what's a practical law document versus what's a secondary, form that's out within the Westlaw universe, but it's not written by the editors. And you can see down here, you've got Ekstrom's licensing. But up here, you'll have your standard document, which is maintained, which tells you that that is a practical law document. So let me click into there and show you what a standard document looks like. So hopefully this is big enough. Let me see if I can resize my screen a little bit. So standard document, this is a patent settlement agreement, and it's drafted from a pro-patent owner point of view, which in my area, a lot of times we draft the agreements both ways. So we have a pro-patent owner agreement, we have a pro-accused infringer agreement, and you won't find this in every situation, but in our area, we tend to do this quite a bit. One of the things about these templates that we have are, as you can see, you've got a document basically pre-drafted for you with the brackets showing where you would need to fill in. But in addition to that, what you have are notes that we embed within the document. This first note, read before using this document, is contained in every single one of the standard documents that we offer. And it introduces you to the document. It tells you about important considerations, potential risks and benefits, that sort of thing. And then you, as you scroll through, you get to the next section of the document, and you'll have a note here on the recitals, and and these are just drafting notes, but they're very helpful, especially if you haven't done a document before, or especially if there's a little nuance to the law that the editor feels is worthy of a note on, let's say, the meaning of affiliate here. In patent law, there may be a note that cites you to a case within the note. So those sort of things can be very helpful when you're drafting. On the right-hand side, and this is really the most important, I think, when you're dealing with the standard documents that we do, but these documents are all in practice notes, checklists. You can email them to yourself. These are all the delivery options. You can print them, you can download them to your computer. You can create alerts. Those are all common. The alert function is nice because you can set it up to send you an email when there's a change in the law. But what this open in Word function with a standard document, what that does for you, and I just clicked on it, and you'll see that hopefully this will load up for me. Getting a lot of slowness here. So that gives you your document in Word. And the nice thing about that is that, you know, you can just download it this way and fill in some of the descriptions, fill in the names of the parties, the title of the action. And this is the case for almost all the standard documents that we do, where you'll have this option to download the document and just start using it for yourself. Save it to your computer and use it. That's what we do. I'm gonna see if I can get to a few more things. I wanted to show you one other thing about this particular document, and this isn't true for all our documents, but this document is powered by Contract Express, which just means that if you don't want to download the Word document to your computer and fill it in, you can start drafting it using an automated form. So, see if this loads up for me. So here you have your agreement, and this form allows you to start typing into the various areas, and it'll fill in the form for you. And then you can save it and close it, and you'll have it at your computer to work through and to make any additional changes that you'd want to make to it. So let me see if I'll close that. Let me take you back and show you one other item, if I can do that. So this is a feature we have, and I'm just back at the task page, but you could be back at our intellectual property homepage, or at the practical law main page, landings page, and find this information as well. But I'm already here. One of the interesting things we have is this what's market feature. So what's market is, it's basically what we do is we take publicly available documents from databases like Edgar, and we summarize them and we make them available for comparison. So if you were to click on license agreements, you could go, and this is going to take a while to populate, but let's just say, let's just pick a type that you'd be interested in. So I'm going to pick a category of intellectual property, and I'm in the license agreements database. And I'm just going to pick trademark because that's what I feel like picking. And I want to see. So that narrowed my search down to 340 documents. And I need to narrow it down further, or I don't think I'm going to, really be able to make a decent comparison. So how about I do exclusive trademark license instead of non-exclusive. And again, these filters on the left-hand side of the screen, these are common to practical law. Obviously not the exact content, because this is a specialized database, but you would have filters like this for jurisdiction. If you wanted to look up California law, you have numerous ways to filter things, and it's all extremely easy to follow. Let me pick one other narrowing feature if I can. I mentioned California, so let's check out California law. So that takes me down to 15 documents. That's manageable. So let me see what we can get here. So these are going to be all the trademark exclusive licenses with a California law bent to them that are in this particular database. I can compare all 15 of them. I can compare just a couple of them. Why don't I compare the first three? And if you click on the compare button, you'll see the 3 documents come up, and you get a sort of just an overview right here. But if you select all, that lets you compare all the terms. So you have columns for the deal, the parties, the industry sector, filing date, etc. There are actually more columns that you can access, and the way to do it is to download this comparison to an Excel spreadsheet, which you can do. Let's see if it'll come up for me. So you can see this spreadsheet takes all the different terms and puts them into a comparison style chart for you. So you could see like term, the royalty rates, and it goes, you know, quite a few columns longer than what I was showing you with the screen a moment ago. So that's one of the great features for a transactional lawyer, and you can do this with a lot of different deals. I'm not sure that I really gave you enough time to see how many of these types of what's market areas we have, but they're quite a few. See if I can get back there fast enough to let you see. And I know I'm running up against my time, but so this is the page called What's Market, and you can do this in a wide variety of areas, again, from antitrust to real estate, and you can make a comparison of some of the publicly available materials. I don't know if I have time to show a matter map, but I'll give it a shot. If maybe I'll be able to do it if I go back here. So again, this is the main screen for our intellectual property page, and here's what we call matter maps. And there's a few different ones that we offer here, but what a matter map offers you, it's like a work process flow for your project. So if you're doing patent license transaction, you get this nice flow of how the project may go. And you can click on any of these, and if we have a resource that applies to, for the example, this one's determining the client business strategy, we have a practice note on that that's about licensing strategy. So I just wanted to show you these because these are downloadable as well. You can download them as PDFs, and I think these can be very helpful in certain situations, especially if you're doing a transaction and you don't want to develop your own outline or workflow for the project. I want to thank everybody for being here, and I think I'll turn it back over to Ann.
So this is Nick, actually. We did have a couple questions come in, so I kind of want to touch on one right away. So there was a question from Victoria about the resources available in real estate. So Bryan, while you have the screen up, can you go to the real estate section quick? So basically with practical law, Bryan kind of focused on the IP, but all the resources you saw for the intellectual property, the practice notes, checklists, standard documents, things of that nature will be available for any of these practice areas here. It'll just be relevant to whatever practice area you're in. So as you pop into real estate here, it'll be, you know, a similar view, but it'll cover different things. So again, off to the left, if you want to click into just one of those, Bryan, yeah.
Sure,
so it'll
sure.
kind of cover, you know, all the different areas that deal with real estate in this example. So the great thing about practical law is that It'll give you up-to-date resources so you can be confident in those areas you might not be too familiar with. And it'll give you a good work product to get out the door quickly. You know, customers now, they have a lot of options. If you can't do something quickly or, you know, good for them, they, you know, or even at a good rate, they can go and find other people. So practical law really helps you address the whole of those client needs. We had another question about if Westlaw Edge and practical law would be sold separately or together. So they are sold separately. If you want, you can have them together. There are a few different options that you can go forward with for Edge and practical law. It really depends on the content you want. So within Westlaw Edge, it depends on what jurisdictions you'd like. So if you wanted to do just California, if you wanted to do federal, things like that, you can go ahead and do that if you want all states, all federal. I did send a flyer to Anne with some promotional pricing for Westlaw Edge and Westlaw. I believe it's up to 60% off on if you did a multi-year agreement. So from there, if there is any questions on the pricing and stuff like that based off of the packages, there's some basic options on that flyer. If you want to customize from there, we can still apply that discount, get you something that really works for, you know, the practice and jurisdictions that you work in. When it comes to practical law, the discount is similar. Then we'll go over to that. With practical law, there's a couple different options. You can have the full boat. So Bryan, if you want to go back to that main page for Practical Law Connect, you can do all the different practice areas. So commercial transactions, M&A, real estate, trust and estates, things of that nature to really have a robust practice and be able to take on some of those clients that you might have, you know, passed in the past. Or you can do individual slices. So if you want, you know, just real estate, if you want just corporate M&A, things like that, you can do that as well. So it all depends on that. But with the discount we were able to get approved with Anne and the Bar Association, we can definitely get something if there's any interest in your hands for a great rate. With that being said, Anne, I believe you will be sending out my information to everybody if they don't already have it. So if there are any questions or if anybody would like a trial to this information or you know, pricing, they can let me know directly and we can kind of work on that. So Anne, anything else to add?
Yes, I wanted to let everybody know that, again, Thomson Reuters and Westlaw are a member benefit provider. And if you go to our website under attorneys and you go to the member center, under member center, there's a member benefits. And if you click on there, not only will you see Thomson Reuters, if you scroll down to the legal research and area, you'll see all the other member benefit providers. But there, for Thomson Reuters, there's a lot of information on the member benefit page about these, about their offerings and what they provide for us and the discounts and all of that. So I encourage everyone to head there as well. And we'll be sending out a few things, but I probably am just going to send out a link to the member benefit page because that's where all the information is housed. And that's where you'll find the best discounts and things. So anyway, so it looks like we don't have any more questions. And thank you again, Nick and Devin and Bryan, for coming to us from Texas and Ohio. And Nick, where are you? You're in San Francisco?
Oakland.
Oakland, okay. And she's not on the panelist, but I want to thank your team, Nick, for putting everything together and getting this for us and for the members. So thank you all very much. And if you need anything else, get in touch with me or Nick, and we will see you soon. Thanks, everybody.
Thanks, Anne.
Thanks, Anne.
In case
Thanks,
anyone
everybody.
was wondering, that's the Rock Hall in the background of my.
Oh, we gotta put it back up, Bryan.
Oh. Well, Devin and I should have had guess our backgrounds as the final.
Mine's pretty easy.
Well, if you're blocking the star, it's not as easy. But now when
There we go.
yeah,
I don't know. It's ostentatious enough to know what it is.
Yeah.
right.
All right. Thanks, you guys.
Thank you, everyone.
Thank
Bye-bye.
you.